Dear colleagues, dear participants, my name is Roman Nikolak. I work as International Relations Coordinator at Center for Civil Liberties. If you are new to our platform, I will briefly explain. CCL is a Kyiv-based NGO founded in 2007. Back in 2022, we received a Nobel Peace Prize. We work on various issues at the OSCE region. We work on IHL compliance, transitional justice issue, and human rights monitoring in Ukraine and OSCE region. Today, it is a second day of Ukrainian Criminal Justice Week, a series of events created by the CCL to honor June 17, the International Criminal Justice Day, the day when Rome Statute was adopted and International Criminal Court in Hague started its proceeding. This year, webinars are co-organized by US and global international law firm PLPG, Public International Law Policy Group. And PLPG was kind enough to invite Ambassador Stephen Rapp to be our speaker today. We will have a lecture of approximately 30-40 minutes, followed by Q&A session. You can ask your question directly by raising a hand in the Zoom or by making a message to a chat, and I will gladly voice them for you. Our previous webinars are available on our YouTube channel, and I will share the recording, the link with you in the chat. If air alarm occur during the session, please feel safe to skip the meeting and seek safety in the nearest shelter. Don't worry to miss out, because the lecture will be recorded and you can revisit it for academic purposes afterwards. Today, Ambassador Rapp will speak about various international law and legal problems surrounding the crime of aggression. And he was chosen because of his past experience in international justice sphere. Stephen Rapp is former US Ambassador at Large for the Global Criminal Justice Program, where he was heading the Office of Global Criminal Justice in the US State Department. Previously, he started his legal and political career in 70s, where he was US attorney for the North District of Iowa, and he was twice elected for Iowa House of Representatives for the Parliament of State Iowa. From 2001 to 2007, he held senior roles at the International Criminal Tribunal for Rwanda, including the chief of prosecutions. Today, he will speak about the legal definition of the crime of aggression and legal and political complication of Kampala Amendments process, so-called Kampala review. And finally, he will speak about future of international criminal justice in Ukraine and the world. Stephen, the floor is yours.
Well, thank you very much, Roman, and it's great to be with you, if virtually today. I have been in Ukraine many times in the past, twice after the initial Russian invasion, the illegal annexation of Crimea, and the attacks and occupation in eastern Ukraine and in the Donbass in 2014 and 2015. While I served as U.S. Ambassador at Large for Global Criminal Justice. Was in that job, by the way, for 6 years, from 2009 until 2015, under President Obama. And frankly, those missions were about persuading the government, and led by President Poroshenko, to adopt the Rome Statute, even though the U.S. wasn't part of it, or to declare under an article of the Rome Statute 12.3, which allows a country to declare jurisdiction from certain dates and certain events, the jurisdiction of the ICC. That initially, if you may recall, the government did that on a very limited basis, only relating basically to the events in Euromaidan. I strongly persuaded them, eventually successfully, to enter a broad declaration that essentially provided the jurisdiction of the ICC from 2014 to the present on an ongoing basis, even without ratifying the ICC, which of course that's since happened recently in Ukraine. And that's the basis upon which the ICC has been able to exercise jurisdiction over war crimes, crimes against humanity, and genocide committed on its territory by Russia, by Belarus, by North Koreans, by whomever. Those are cases that, of course, have resulted in several arrest warrants having been issued by the ICC. Of course, today we're talking about the crime of aggression. And let me just state, and I should note as well, after the full-scale invasion of Ukraine in February of 2022, I came to the country 4 times. And I've also been involved in a people's tribunal, the Court of the Citizens of the World, where we held a hearing in The Hague in February of 2023 on the first anniversary of that full-scale invasion, where we had the testimony of your executive director, Alexander Novichok. I'm very proud to be here again with the CCL, and its Nobel Prize was well earned and continues to be earned by your leadership in this area. But we, the 3 of us sitting as judges, which included a South African former Supreme Court judge and also a legal scholar from India, unanimously found that there were grounds to confirm an indictment against Vladimir Putin for the crime of aggression if there was jurisdiction. And we, of course, were a People's Tribunal that said, yes, as a People's Tribunal, we had jurisdiction, but we needed a legal tribunal, one that could actually exercise powers to then constitute a trial and hold Putin and potentially others to account. And frankly, I would say it was not a difficult case in terms of what the Russian leadership had done in Ukraine for the crime of aggression under the Rome Statute. But of course, our challenge to date has been the absence of a court with jurisdiction to prosecute this case. Now, before I go on and talk about the legal limitations of the ICC and the efforts to resolve those legal limitations, we first of all, I think, have to look at the good news, albeit it's taken a while, that we do have this agreement between Ukraine and the Council of Europe to establish a special tribunal on the crime of aggression against Ukraine. And that statute is now out there. The agreement has become public, and real progress is being made to actually stand up a special tribunal based upon the territorial jurisdiction of Ukraine for the aggression that's been committed by Russia, frankly, since 2014. It's important that tribunal actually begin its work. As if you've studied it closely, you'll know that a key element that remains is the establishment of an agreement so it's called a partial agreement for the support of the court, states coming forward, among those in the Council of Europe. It also can include states from outside the Council of Europe that can ratify that partial agreement for the support of the court. And that's essential to then having a management committee and a budget, et cetera. And a key part of the statute and the agreement so the court will only come into being once and 2 more years play basic funding, but it's really going to be necessary for states like Germany and others to step up and finance this court. And I myself, having been a prosecutor of an international court, being a senior trial attorney and a chief of prosecutions at the Rwanda Tribunal, that was established by the UN Security Council, and I lived in East Africa for 6 years, from 2001 to 2007, and prosecuted those responsible for the Rwanda genocide. That court was supported by the UN under regular dues, and we were able to do our work without interruption. Later on, I became the chief prosecutor of a special tribunal or special court in West Africa, that was dealing with the massive crimes committed during the Civil War, some of which the neighboring president was responsible for. And our court found that the neighboring president, President Taylor of Liberia, was responsible. And our court was established in very much the same way as this aggression tribunal. It was an agreement between Sierra Leone, providing its jurisdictional jurisdiction, so to speak, its right to prosecute cases in its own country. It had given that to a court that was sponsored by an international, and that court was able to eventually bring him to trial and convict him. But we also had to support ourselves by voluntary contributions. And raising the funds to keep that court going became one of my major responsibilities. I couldn't go to court. I was out trying with begging bowl, trying to get the money to do it. So that's sub-ideal, and it's one of the reasons why one would prefer, if possible, for the International Criminal Court, which has a regular budget, 125 members who pay dues, some slow, some fast. At the moment, everybody's paying their dues, and you can finance the court. So that's one of the advantages of going to the ICC. That said, it's important to note that everything the ICC has ever done has only been prospective. Other courts can be established after the fact under agreements and apply international law that was in effect at the time. But the ICC is generally, and indeed in its statute, always requires that the agreement be made first, and then you can prosecute for crimes committed later. So even if the ICC were miraculously to change its statute to allow it to prosecute the crime of aggression in Ukraine, it would only be for crimes committed after that ratification. So the issue of moving forward with change in the ICC jurisdictional regime is one that is important, I think, for Ukraine, as Alexandra in her speech discussed in the Assembly of State Parties Review Conference, which occurred last week in New York, in order to say to the whole world, this is not a one-off thing. This is not something just because we care about aggression in Ukraine, Europe, but we also believe that this principle needs to apply everywhere. And it's very important that that jurisdictional regime be changed so when aggression occurs in Latin America or in Asia or wherever, that in the future, there's an ability to reach it. And so that brings us back to the Rome Statute and the way in which the ICC was established and the ways in which that statute as it stands now doesn't reach the aggression, frankly, committed by Russia on the territory of Ukraine since 2014, even though Ukraine has been able, by a declaration filed with the ICC, to provide territorial jurisdiction to the ICC for war crimes, crimes against humanity, and genocide. And before I go there, let me just say, in my view, why that's so important. And I suppose speaking to a group of Ukrainians, I really don't need to make this point, but I make it constantly when I travel, and I travel 240 days a year, supported by the U.S. Holocaust Museum in dealing with crimes committed globally, and I'll be back to Syria for the fourth time since December. I'm dealing with crimes committed in Africa and in Asia and elsewhere, trying to establish the means to accountability. But what's struck the world about what happened, particularly with the full-scale invasion in 2022, is a peaceful people going to work and school and about their lives when suddenly on February 24th, death starts raining from the skies, and then everything that has followed, and now the hundreds of drones and scores of missiles that are launched against civilian buildings and neighborhoods and everything else that the people endure. If you were talking about the kind of crimes that the ICC has jurisdiction of, war crimes or crimes against humanity or genocide. I hear an interruption. Do we have an issue with the sound?
Yes, please continue. Sorry for that.
Okay. anyway, to say that as one builds these cases, we've certainly seen the ICC put together cases on the forced deportation of children and on attacks on civilian infrastructure, and we look forward to them charging commanders and others that were within that chain of command for crimes in places like Busha and Izium. That to prosecute a war crime, you have to deal with the question of whether a particular act is a war crime. When it comes to bombardment, for instance, by missiles or drones or sea-launched missiles, you always have this difficult issue of figuring out what the military target was. And if you were shooting at a military target, and even though there was collateral damage, that may not be a war crime. And of course, proving what their intention is always difficult. So even though horrendous damage, hundreds of billions of dollars of damage have been done to the country, and thousands of people have lost their lives, including civilians, you can't prove a war crime unless you make it fit under these narrow grounds where you have to deal with the kind of intention of the shooter and go to trial and say there was no military advantage to this particular attack, or it was disproportionate to that military advantage. So even the most aggressive prosecutor would only be able to prosecute a fraction of the damage done to human life and buildings and infrastructure as a war crime. And a crime against humanity requires an explicit intent to attack civilians. Now, we think that's what they're doing at the moment. We can potentially prove that. But that's, again, limited. And of course, genocide, we could talk about. This is not the purpose of the speech. We know the difficulty of genocide in proving the intent at physical destruction and the way the courts have limited that and excluded cultural destruction or attempting to take over a country and change its language, for instance. If the people survive, that's not genocide, the courts have said. And so this is a narrow thing. But then you look at what's happened in Ukraine, and you look at the immense loss, and you look at, for instance, the cost to combatants, the conscripts and the volunteers who by the tens of thousands have joined to fight to protect their country. They've been killed on the battlefield. And then killed on the battlefield. Those aren't war crimes. Now, there's an argument now in the Human Rights Committee that because comes to a crime of aggression, those are violates of human rights potentially, but it's not a war crime. And so all of that suffering isn't included. And this is why at Nuremberg, the prosecution of the Nazi leaders, led by a great hero of mine, a U.S. Supreme Court Justice Jackson, said that this is the supreme crime. And as the judges then said in convicting the Nazi leaders, they said that this crime contains within it the evil of the whole. So all of this destruction and those combatants, those young men and others taken away from their lives and their schools and their families, et cetera, that have died, those are all results of the crime of aggression. So if you're going to deal with the whole thing, you need the crime of aggression. And if we're going to deter these crimes in future, we need a system where there's an expectation that there's going to be prosecution. So that's the fundamentally where I come from. But then let's go back and talk about what the ICC limitations are and why and how they originate. Going back to 1998, when the Rome Statute was negotiated in Rome in a conference. I will say I was not there. I was at that point a federal prosecutor prosecuting organized crime and their ordinary kinds of crimes in my home state of Iowa. I watched as the extent I could from a distance. And it was decided there that the ICC would have jurisdiction of war crimes, crimes against humanity, genocide, and aggression. But there hadn't been a definition of the crime of aggression agreed to. So it was decided to defer that until a review conference could be held at least 7 years after the ICC had been stood up. ICC stood up 23 years ago this week on July 17th, 2000, in July of 2002, when more than 60 countries had ratified. A review conference is then scheduled for 7 or 8 years later in Kampala, Uganda. And I was the co-chair of the U.S. delegation to that Kampala conference. It was then to decide what to do about the crime of aggression. Now, from the point of view of my own role, I come to this appointment by President Obama, and very much wanted to see the United States become much closer to the ICC. The U.S. had taken a very negative view of the court initially, had passed a law in Congress in 2002 called the American Service Members Protection Act. It had three-quarters support of our Congress. It was essentially presented to Congress on the basis that Americans who were out in the world protecting people and engaged all over the place, almost usually with permission of governments, could be prosecuted left and right, and therefore we needed to protect ourselves. But it was an outrageous law that limited our ability to assist the court, even though the United States had been a leader at Nuremberg in getting that tribunal going, and been a leader in establishing the Yugoslavia and Rwanda tribunal and the Cambodia tribunal and the Sierra Leone tribunal, where I served as chief prosecutor. But we turned our back on this one. And in the first decade of this century, there was a discussion and working groups where the question of aggression was discussed, and a draft definition was written and agreed to, at least informally, by ICC member states. And even though, frankly, Russia and China participated, the U.S. under President Bush didn't participate at all. When I became ambassador at large, one of my priorities was to get the U.S. into the ICC, or we couldn't be a member, to become a partner to it and support it. This American Service Members Protection Act included an amendment by Senator Dodd that allowed the U.S. to support the court in a case involving a non-citizen alleged to be responsible for genocide, war crimes, or crimes against humanity. And I wanted to make maximum use of that to be able to support the court in the important cases that it was then doing in Uganda, in Congo, in Ivory Coast, in Kenya, and elsewhere. And indeed, I had been, as a prosecutor, dealing with crimes committed essentially in civil wars, or sometimes not even in wars themselves. But though there may have been some foreign interventions, as there was in Cambodia, the foreign intervention was actually to stop the atrocities, as the Vietnamese did in 1979. And it, for many of us, looked like in the period since World War II, the issue of interstate aggression had become extremely rare. One of the few examples that we think of was the invasion of Kuwait in 1990 by Iraq, and the world coming together, even with the support of Gorbachev, to resist that and push back in that particular invasion. But what was happening and what I was responding to were the crimes that were happening within countries. The world in 2005 adopted at the General Assembly unanimously a responsibility to protect that at least created a possibility that there could be intervention in a state if there was absolutely failure of them to do anything to stop a genocide or crime against humanity or war crimes within a civil war, that an intervention could be made to protect people from those crimes, specifically as delineated. And so in 2010, we were not looking at interstate aggression. We were looking at trying to be more effective for those crimes in Congo or Uganda or Mali or Cote d'Ivoire or wherever, that there were massive exactions against the civilian population. Situations like I had in Rwanda, where there may have been a civil war, 100 soldiers died in the civil war, 800,000 civilians were killed intentionally because they were supposedly in support of one side and were killed because their ethnicity was then viewed as the enemy. And so those were the kinds of crimes to which we were responding. So to be frank, in terms of our U.S. government negotiations, U.S. military didn't want to agree to us going to the ICC or participating. We said, look, we'll go and help you on the crime of aggression for fear that you're going to get prosecuted on it. But at the same time, we'll establish a principle that the U.S. is going to assist on war crimes, genocide, crimes against humanity in every situation that's out there. So we came to Kampala, and of course, Kampala involved the 120 or so countries that were then in the ICC. And in any amendment to the statute defining the crime of aggression and establishing the jurisdictional framework would have to be agreed by at least 2/3 of them. And 2/3 of those that were members, whether they were there or not. And many countries didn't come. And so toward the end of the conference, there were only 80 or so there. And it was a situation where anything that happened would have to have unanimous consent because a 2/3 vote may be almost impossible to achieve. And so the issue became how they were going to achieve unanimity on this particular thing. Now, there are two countries in the UN Security Council among the permanent five, France and UK, that are members of the ICC. Of course, there are three that are not: the United States, Russia, and China. But Russia and China were there and arguing very vociferously that the ICC couldn't proceed with aggression unless, and the definition that had been proposed was aggression was defined as an act of aggression of such character, gravity, and scale that it constituted a manifest violation of the UN Charter. Well, if you look at the UN Charter, it says that for there would be an act of aggression, the Security Council has to decide that there's an act of aggression, and it's specifically in Chapter 7 of the ICC of the UN Charter. So Russia and China said, you can't do it. You can't do it all. You have to have a Security Council thing. Security Council thing, you can proceed. And of course, everyone says, well, what if you don't agree? What if you veto, et cetera? How are we going to reach that particular situation? And so our American position, to be frank, was we were concerned that there would be situations like the Vietnamese coming into Cambodia, or a situation like Rwanda or Srebrenica, where you'd need international intervention, not just a court to stop it, an intervention force to go in and protect people. And that could be viewed as a crime of aggression. So, and our friends said, no, that wouldn't be a crime of aggression. We said, well, who says it's not a crime of aggression? And so our friends worked to try to provide some understandings, which I thought were extremely helpful, that said it would, that in determining whether something was of a character, gravity, and scale to constitute a manifest violation, it would have to be a combination of the three. If you look at Ukraine's situation, and you look at a situation where some intervention force comes in to protect people and leaves in a week or two after they're protected, that would not be the scale. And it would be done for the motivation of protecting people, not to occupy or control the country. And so it wouldn't constitute an aggression to do that kind of thing. And I frankly thought that was very helpful. But those who were concerned, Britain and France, et cetera, and the Security Council, et cetera, said it's still not good enough. And then the sponsors offered the particular amendment that we see at 15 bis 5, which says that essentially created this different jurisdictional regime that basically said that in the case of a crime of aggression, there would be no jurisdiction over the citizens of a non-party. And then additionally provided provisions that even a party could opt out in terms of its citizens, essentially creating a rule that for those who adopted the amendment, that to have a prosecution of aggression, both the country that was the aggressor and the country that was aggressed against would both have to be state parties to the Rome Statute and to the amendments, and not have opted out. Obviously, a very limited approach, and that's what was offered, and that's what gained consensus at the time. Then in the U.S. we were able to proceed and to assist the ICC establish rewards on its fugitives, help bring two of its major suspects, the only two that have received life sentences, surrendered to us, and we delivered to the ICC. So that's how things proceeded after that. And then, of course, the world became quite different in terms of Russia's aggressive position in the Security Council, vetoing any referral, for instance, of the situation in Syria on the horrible crimes that were being committed there. Vetoed that resolution in May of 2014, and of course in 2014 engaged in the illegal annexation of Crimea and the invasion of the Donbass, et cetera. And since then, we've had a situation where it's been almost impossible for the Security Council to agree to anything. And so the system has been blocked. My own personal position, and of course, when I was an ambassador, I was taking instructions from my government, though I was involved in the negotiations to reach those instructions, is that this particular provision was written for a different world than the one that we were in. It was written at a time when the major concern was civil wars, and we thought aggressive war across borders was fundamentally a thing of the past. And now I think it's appropriate to move forward and change the jurisdictional regime so that any state that adopts the ICC can essentially protect its territory against persons from a state that's not in the ICC committing the crime of aggression. Now, as you may know, this issue has recently been considered, and do keep in mind, as I said earlier, from Ukraine's point of view, it doesn't directly affect Ukraine because it's going to be prospective, anything that happens in this space. And before an amendment can be adopted, you would need 7/8 of the state parties of the ICC to adopt the amendment. Because it's not an amendment to the definition of a crime, it's to the conditions for the exercise of jurisdiction. So you will eventually need 108 states to ratify an amendment to change this jurisdictional regime. Now, so far, only 49 states have adopted the aggression amendment itself. So we're a long ways away from the day that this change would be made, but it's important to begin the process. But it won't be for Ukraine, but it's important to Ukraine. Because obviously other states whose support is important, and we know the challenges that Ukraine has had in getting, for instance, UN General Assembly to agree to a court, which is my preference. I would have preferred that the UN General Assembly, which of course famously voted with 141 votes to determine that this was an aggression and to support Ukraine several times and oppose the illegal annexation of the 4 provinces, et cetera, that's occurred by Putin's phony referenda, in addition, of course, to Crimea earlier, that we've had strong support. But on the other hand, when we moved for throwing Russia off the Human Rights Council or to create a registry of damages, we only had 90-some support. Many people thought that, if we moved tried to get approval of the Aggression Tribunal and the UN General Assembly, it could be less than that. Now, many states would abstain, and we might still have 2/3, which would be required. So you could get, 80 votes yes and 40 votes no and 70 abstentions. That wouldn't be a very solid basis to do this. And so it's very, very important from the point of view of supporting action on aggression that the world see that this is not just for Ukraine, that there will be a future possibility of prosecution of aggression in other situations. And for that reason, I frankly, personally, and said so in a recent conference sponsored by the U.S. military in Kuwait, that I thought that we were fundamentally protected by the understandings that were adopted in Kampala that said any action would be evaluated in terms of character, gravity, and scale, and the kind of things that we should be doing as a country would not be aggression if we were to intervene to protect people in a Srebrenica kind of situation, and that we should go along with this amendment. That's not, however, the current position of the U.S. president, who sent, even though the U.S. has sanctioned the ICC now over the Israel case, and President Trump has sanctioned the prosecutor and sanctioned 4 of the judges that come from Africa who ruled against the U.S., ruled against the Israeli position or U.S. position on certain things. The U.S. came and threatened the ICC at this conference and said, if you do this, we'll we'll come after you even harder than we are now, which is about the worst way. You can go to a meeting and try to persuade people. But on the other hand, there were a number of other states, particularly led by Canada, obviously not a state that's getting along very well with the United States under President Trump, as you may know at the moment, with 35% tariff currently planned for August 1st and all of that. But Canada basically took the position, look, we've only got 49 states that are in this thing so far. We had this agreement at Kampala. This isn't going to count for Ukraine in any case. We need to study this thing further and wait until more states have ratified. Everybody said, well, that could be forever. Let's get this moving. And so the agreement was that the matter would come up for consideration in 2029, 4 years from now, and that there would be an intercessional session in 2027 to discuss and to move the thing along to achieve progress. At the end of the day, as I say, we'll see how it goes. I think the pressure will remain there to, as they say, harmonize the jurisdictional regime. Again, why harmonize? It comes to war crimes, crimes against humanity, genocide. Your territory is protected if you ratify the ICC or you give a declaration. It comes to aggression, then you've got to be in the ICC, you've got to be in the you've got to ratify the amendment, and the state that sends the soldiers to invade your country would also need to be in it, which of course we can't imagine Russia under its current leadership ever being in it. So, or North Korea, who might be invading South Korea, or China, which might be invading Taiwan, et cetera. They won't agree to it, so it won't work. And there were countries I should note that were there. Armenia is very concerned and views what happened in Nagorno-Karabakh, et cetera, and the ethnic cleansing there, and the threats against Armenia proper as aggression. It spoken, of course, as you know, even though it was in the past pro-Russia within the constellation of Commonwealth of Independent States, so to speak. It's now turned against Russia because Russia did so little to protect it from Azerbaijan. It said, we need this. Guyana was there saying that, Venezuela wants to take half our country. So there are a number of other places that say we need this, and we will see whether that change is made. But it will continue to be debated. Of course, fundamentally to all of this, we need to have more states ratify the amendment, or it's kind of crazy to say we want to change this for 125 states when only 49 so far have even made the step of ratifying it under the narrow jurisdictional grounds that it presently has. So that's where it stands at the moment. But from a practical point of view, it's important to, I think, one, get this crime of aggression tribunal going. And let me note there, of course, it's not perfect, but we still have, head of state immunity issue in the sense that the prosecutor can file an indictment against Putin, but it can't be approved or an arrest order issued unless he were no longer in office. So it's not perfect in that sense, though I'd certainly like to see an indictment. Of course, this is because of a provision of a decision of the International Court of Justice in 2002 that immunized the troika, so-called, the president, the prime minister, and the foreign minister. But this certainly does permit cases to be brought against former Defense Minister Gerasimov, against generals and others, against in active prosecutions. And as you know, unlike the ICC, will provide, as does Ukraine, for in absentia proceedings to occur with those in absentia defendants represented and at trials held, which is, I think, important symbolically, even though that's not something that we in common law countries like the US or Britain, et cetera, do. But I think understand that under international law, those people would have to be retried if they're eventually arrested, but that allows proceedings to go forward against the Gerasimovs, for instance. But if you had then Putin being retired out, hard to imagine him wanting to leave office while he's alive, but we will see. Then, of course, he could be prosecuted, and the trial could be conducted, presumably in The Hague, before all the world, before judges who were elected by this system, and people could testify, and judgments could be rendered for reparations and for relief of victims. So I think it's important that full speed ahead on this one, to get states to agree to it, to get to get Netherlands to adopt a host country agreement, and to have this court up and going within the next few months. So with that opening there, we've got I think 20 minutes for your questions. Let me go ahead and yield to your questions.
Steven, thank you for this great presentation. And we have a first question from Miss Marina. Marina, if you're currently hearing us, maybe do you want to raise it by yourself? You can unmute yourself.
Yeah, sorry if it's loud here. I think the question was partly answered, so maybe I can raise another one. We all know that the Council of Europe concluded the agreement, and so now the Special Tribunal for the Crime of Aggression against Ukraine is going to be hopefully ratified. The question is, given that these high-level officials enjoy immunity, meaning like Russian high officials, and that only United Nations Security Council, where Russia holds veto power, can waive this immunity, how do you see the possibility of enforcing accountability in practice within this criminal court that is going to be established? Do you see the special tribunal as primarily symbolic, or do you believe it can have meaningful impact, even if they are not going to be arrested now? And another question would be, given the regional nature of this tribunal to be established and the fragmentation that we can see, meaning, for example, Hungary is not being in favor of the establishment of the tribunal, and also the Slovak foreign minister suggests Russia to be forgiven. How do you see the effectiveness of all of this? Thank you.
Great question.
Those are excellent questions. Do keep in mind, I mean, we are in the internet, in a world of states. We don't have a transnational government with authority to enforce judgments, etc. We've had success at these ad hoc tribunals for the former Yugoslavia and Rwanda. In fact, because there was at least, in the case of Yugoslavia, a transition from Milosevic to others, or maybe nationalist leaders, but saw the advantage of cooperating with the court. And obviously in situations like Rwanda, the bad guys may have won the genocide, but they lost the country and went into exile, and it was possible to chase them up in 26 different countries and bring them to trial in Arusha and Tanzania, where I was a prosecutor. Obviously in a case like Cambodia, between the overthrow of the Pol Pot government and the standing up of that tribunal, there was a period of about 28 years, and then it wasn't until really almost 40 years after the crimes were committed that the chief of state was and the number two official under the political leader, Pol Pot, were convicted in court. So, and that, of course, was following a transition to an imperfect government, but one that would nonetheless cooperate with the prosecution of these former high-level leaders. So international justice is often slow unless there has been a complete defeat of or a transition in the country that whose leaders, whose soldiers, whose forces committed these crimes. That said, it's extremely important, as the ICC now, to issue an arrest warrant against Putin, Maria Lvova, and that initial indictment, perhaps in future ones as to him. He hasn't been able to go to the BRICS conference in South Africa or in Brazil. He's curtailed. He may think he can continue to do what he's doing, but he's not what he was. He'll be, and that indictment won't go away. I mean, if there were a peace negotiation in Ukraine, if, for instance, sort of Trump's vision of all of this, of some kind of agreement were to occur, a ceasefire with non-recognition of the gains, but toleration of those gains. Would there be an elimination of justice at the ICC or at this international court? I don't think, frankly, that there would be. The ICC doesn't have the ability to dismiss a case because of a peace agreement. The Security Council could defer prosecutions for a year at a time. There'd be many states that would oppose that, and it would take 9 votes and no veto, and that would have to happen year after year. The U.S. could have a new president who would say, no, Russia should continue to face Russian leaders for prosecutions for the war crimes that they committed. So, as I say, there are political obstacles that are there and realities that are there. And so, yes, a lot of this is symbolic, but it does have a bite. And when it's accompanied with sanctions and abilities to recover assets that may be found in third states and get those to the victims and survivors, et cetera, those are meaningful things. And as everyone notes about international justice, it's been possible to deal with Milosevic or to deal with Charles Taylor or with Radovan Karadzic or John Kambanda, the Prime Minister of Rwanda, leaders of relatively small states, but actually bringing the leader of a state that's undefeated, Russia, to trial is a challenge that's not been bit off before. If the ICC had existed in 1944, you can imagine what the reaction would have been on the right chancellery in Berlin if Hitler had been indicted. He wouldn't have surrendered and gone to a trial. It was necessary in the end to defeat him. So, I mean, that is still a reality in our world. But the prospect of being held to trial and the fact that these arrest warrants do not go away, and that there are Nazi camp guards that are 101 years old now that are being tried for what they did when they were 19, sort of sends the message that if you commit these crimes, there's no resting in this life. They will be after you. And to the extent we establish these courts and provide them with support and use political leverage to bring the perpetrators to justice, don't make agreements with Russia on end of sanctions or unfreezing of assets, et cetera, unless they cooperate, which is what was demanded of the countries of the former Yugoslavia before they could move forward in the EU, get off the sanctions, et cetera. That's important. That's what I was working for when I was ambassador at large. And that takes state support from states small and large to work. So I think it's meaningful, but it won't solve the problem tomorrow.
Ambassador Rapp,
Thank you.
Thank you. And we have a question from Katerina. I will read it. Do you believe there is still a room to revise or reinterpret the Kampala Amendments to make them more usable in current geopolitical realities, especially in case involving major powers?
Understand the Kampala Amendments would include a provision, of course, under 15 ter of the Rome Statute that would say that, of course, this could be applied if there was a Security Council referral. And of course, we know when we're talking about the 5 powers that are permanent members, if any of them oppose it, it's not going to happen. And that's why no one's given that any consideration whatsoever. We know Russia would veto this, as they vetoed the declaration that was put before the Security Council in February of 2022, finding that they committed an act of aggression. So I don't see, absent a unanimous interpretation of the amendments by the state parties of the ICC, which presently several states are objecting to, that you could change the interpretation of the Kampala Amendments, which very explicitly say that the citizens of a non-party are not cannot be held for the crime of aggression committed even on the territory of a party, and that's pretty clear. And so I think that needs to be changed. That 15 bis sub 5 should appropriately be repealed, and the jurisdiction established in the same way as for other crimes. I do keep in mind, from an American point of view, we have long argued, well, we're not under jurisdiction of the ICC because we haven't ratified the statute. So even if we're alleged to commit a crime in a state party, a war crime, we're not responsible. We're not, can't be held to account. That's the position that the U.S. has taken as a matter of policy. It's one that I always opposed, and I never actually wanted to vocalize because I think it's nonsense. I think if I commit a crime in Kyiv, it's the Ukrainians that will decide what happens to me. I don't say, oh, I'm an American, I'm entitled to a jury trial in Washington, D.C. No, if I commit a crime in somebody else's country, then it's up to them where I should face justice for that crime. And that's territorial jurisdiction. And any state can, in its sovereign right, send that case to any court that it wants to, as long as that court complies with basic due process and national human rights. So I think territorial jurisdiction should be well respected, and certainly the ICC found that alleged crimes committed through enhanced interrogation, torture, mistreatment in Afghanistan, which was a state party, was subject to the ICC and was a subject of an investigation. Unless the U.S. could be shown to providing accountability for those crimes in its own system. As you know, the Rome Statute has this idea of complementarity. States have the first bite at it. The current prosecutor said that the United States have done enough on accountability and is deprioritizing it. But of course, we also have that coming up in the context of Palestine having become a state party and having given jurisdiction to the ICC over crimes committed in its territory, which include Gaza and the West Bank. And so there's jurisdiction there, even though Israel says, no, there's not jurisdiction. So the ICC on the ordinary crimes has made it quite ordinary. They're not ordinary, they're extraordinary crimes, but the international crimes and genocide, war crimes, crimes against humanity, there is territorial jurisdiction. But to change it for aggression will need a change in the Rome Statute. Full stop.
Stephen, thank you. And we're almost at the end of our session. If there is no question in the nearest time, we will proceed with the last one. It's about the Rome Statute and the statute of crime of aggression of the Special Tribunal. What could be the possible formats of interaction between the ICC and the Special Tribunal for the crime of aggression against Ukraine, supplementing each other? So, in your opinion, how possible cooperation will be done?
Well, I think that there's great potential for cooperation. Understand, as you may know, that the prosecutor of the ICC, who since stepped aside temporarily because of this individual complaint, but initially took the position sort of against the Tribunal for Aggression, saying, look, I've got these other crimes. We can get the guys, charge them on this. Why waste time and create another court? He became less vocal on that. ICC's state parties also became leaders on this aggression issue. Among them, Germany, Liechtenstein, others who are strong for the ICC said, we need an aggression court too, also. And so that's a very good thing that we have the aggression tribunal coming along. But part of the reflection of this was this danger of competition or duplication. And so we see in the agreement and in the proposed statute this provision for cooperation. And certainly as Ukraine develops, as evidence is developed in the Ukraine war crimes context, there's enormous amounts of evidence that the ICC is gaining about the effect of for instance, Russian bombardment and other damage inflicted as part of the aggressive war, which may not be provable as a war crime. because they can't show for sure that there was not a military target. That's a double negative, but it's what you have to do in this situation. So they've obviously investigated a lot. I mean, I'm very close to Brenda Hollis, who is an American military lawyer initially, was my successor at the Special Court for Sierra Leone, who led the investigation of Ukraine and wrote the indictments, wrote the arrest warrants in all of the cases so far that have resulted in arrest warrants. And certainly she was collecting massive amounts of evidence with the cooperation of Ukrainian authorities, with the cooperation of states that had developed intelligence, et cetera, that had declassified it, made it available. And so I think that kind of information should be shared with the tribunal and would help its case and make sure that there wasn't duplication. And it's very important as we finance this aggression tribunal with state contributions, but without the benefit of U.S. money, et cetera, probably at the moment, though I'd like to see the U.S. contribute, but that we don't overspend. It's got to have to be done in an efficient way if sufficient funds are to be raised. And that means avoid the duplication, work with the ICC, don't do the same thing. And certainly if this team develops information on things that could be war crimes, they can share that back with the ICC too. So I do think this is practical, and I certainly knowing that the line attorneys and the investigators at the ICC, I think there's a positive possibility for cooperation here to essentially lighten the load on the aggression tribunal, and I think that's a positive thing that's in the statute. Anyway, thank you for hearing me today, and I look forward to being back in Ukraine and to victory against the aggression in the field of battle, Slava Ukraine. Important that the rights of the people of Ukraine be respected, and that Ukraine move forward as an independent member of the international community, not as a little Russia as part of Russia, but a proud country of which all of us are so proud to be a partner.
Steven, if I may, we have Edward raising hand. If you have the last question, he would like to voice it by himself. Edward,
yes.
Please.
Good afternoon, Mr. Ambassador. First and foremost, thank you so much for sharing the insights of your expertise. That's a huge asset for all of us. And the reply for your statement was Heroям Slava. We do value your support, but we still have a couple of more questions concerning the aggression towards Ukraine. What I personally feel is that whenever you're looking to the statutes of the tribunal on the aggression and all other tribunals like ICC, like former Yugoslavia, even the rest of the tribunals, especially whenever you've been involved in these practical activities, like everything that we might see is we have to care much about the rights of witnesses. We have to care much about the rights of accused. We have to care much about the fair trial right. We have to care much about the jurisdiction. We have to overthink about the rule of law, of ne bis in idem clause, or ex post facto law, or jurisdictional issues. But there is nothing that we might see towards the punishment of war criminals. Don't you think that it is the dangerous trend that even in your speech, you've never used the word punishment of evil? We have responsibility, we have liability, alleged responsibility, but never punishment of evil, at least evil. It is thought that Ukrainians is seeking justice or something else, but people, ordinary people, they're seeking punishment of these kind of people. Is it so hard to at least proclaim that Ukrainians are seeking justice that would be realized through the just punishment, the severe, the adequate punishment? That is something that is really curious for me, why nobody is saying that crime has to be followed by punishment. If we are caring much about the legality, the of the tribunal? Why don't we care much about the punishment of people? And if we are caring much about the rule of law, why do we have to provide 30 years of imprisonment or life imprisonment in the statute of the tribunal as European case law practice is against that, as our judges, respectful one, they do say that it is the violation of human rights. So we are a priori having this kind of rule of law problems. And in this perspective, I'm wondering about your opinion about the perspective of this international criminal justice. What would be the future of the International Criminal Court that is being sanctioned by the United States of America, that are coming to us, persuading to join International Criminal Court? So why don't we persuade the United States of America to join this court before? And the very last question is, what principally changed whenever we did ratify the Rome Statute, as Ukraine has previously did that twice in a row? Is there any changes after the moment of the ratification? So why it was so significantly to ratify the Rome Statute, having two declarations that are giving us a consent to the jurisdiction of the International Criminal Court? Thank you so much.
Well, let me just make plain, I want to see Putin and all of the perpetrators punished, to the maximum extent of the law. And I'm reminded of the speech of Justice Jackson at Nuremberg, where, of course, at that time, under international law, it was possible to have the death penalty. He said that if we have an unfair trial here, if we don't respect the rights of the accused, we're raising a poison chalice, and that poison chalice will, be one that we will have to sip from as well. People in Syria, where they've had, 130,000 people still missing, tortured to death by the government, by the Assad government, and people are passionate about achieving justice, but they've been in a system where trials were jokes, and where anybody the regime hated was convicted, as we see in Putin's Russia. And we don't do justice with an unfair trial. And we hold ourselves to the kind of burden that we would want someone to sustain if we were falsely accused. That accusation isn't enough to get you there. It has to be a fair process, or it doesn't stand the test of time, and it will be subject to denialism and everything else in the future. So it has to be a fair trial, but all the resources have to be deployed to make sure that the facts can be presented and that the guilty are indeed found guilty. So I make absolutely clear as a prosecutor, whenever I deal with evils that I see, in my mind, I'm seeing the horrible person that has committed those crimes and want to see those evil acts redressed, and for those perpetrators to be punished. Obviously, I personally like to see the United States join the ICC. There's not political support for it. The United States has been very reluctant to ratify a lot of conventions and treaties that everybody else has ratified. We're the only country that hasn't ratified the Convention on the Rights of the Child, et cetera. Very difficult in our politics to join these things. But we can try to help and contribute as much as we can, and then ensure that if we're alleged to commit crimes, that our system is holding those people to account, not perfectly, but we've obviously had situations where senior leaders in the U.S. have been held to account for crimes. So, I listen to that, and I hear it, and I recognize that American leadership is faulty in this area if we're not party to it. But I have to deal with that reality and then do everything I can to make it possible for justice to be done. And justice, as you say, includes, after conviction, in a fair trial with attorneys representing the accused and pointing out every hole in the evidence they can, after that fair trial, the maximum punishment allowed under international law should be meted out to those that are convicted.
Ambassador Rapp, thank you for the final question answer, and we wish you a successful future encounters with Ukrainian audiences. We are grateful for your career in pursuing support for international criminal justice system for more than 25 years. And we hope to see you at the future events. Thank you.
Okay, thank you. Have a good evening. Take care. Bye-bye.
Bye, everybody. Колеги, ми закінчили на сьогодні.